Hi, may I speak to Yukob Rolander?
Yaku, yes, this is he.
Yuko. I'm sorry, pronounce it again?
Yaku.
Yeah.
Yeah, Yaku. It's Hebrew.
Okay. And this is Hearing Officer Solomon with the Texas Workforce Commission. Do you have anyone that will be participating on your behalf today?
No.
Okay. If you'll hold on just a minute, I have several witnesses to connect.
Okay.
Hello?
May I speak to Don Wilson?
Speaking, please.
This is Hearing Officer Solomon with the Texas Workforce Commission. Are you ready for the hearing?
Yes, I am, ma'am.
Okay, and I'm showing two witnesses, Bill McLeave and Yvonne Allen. Are those correct?
That's correct.
Okay, and do you want them all connected for the entire hearing or just when their testimony is needed?
Just for testimony for Mr. McLeave, but the entire hearing for Ms. Allen.
All right, let me go ahead and get her online.
Human Resources, Kroger.
Hi, may I speak to Ms. Allen?
This is her.
This is Hearing Officer Solomon with the Texas Workforce Commission. Are you ready for the hearing?
Yes, I am.
And, all right, so that's everyone I need to connect now, but I will call and connect Mr. McLeave when his testimony is needed. All right, so it is now 9:35 a.m. on February 17, 2022, in appeal number 3032118. The claimant is Yaku Rylander with the last four digits of his Social Security number of 0406. Is that correct, Mr. Rylander?
Yes.
Okay. And the employer is KRGP Incorporated et al. With the employer account number 07-754425-9. Mr. Wilson, is that the correct employer account number as far as you know?
Yes, ma'am.
All right. Now, because the employer has more than one person present, I need the employer to designate a primary representative. The primary representative will be the person that will handle all the procedural matters for that party, which will include such things as getting the opportunity to question the witnesses and examine the documents. Mr. Wilson, who will be the primary representative?
Myself.
Okay. All right, so we sent out a notice of a telephone hearing along with the packet of claim documents. That's pages 1A through 37A. Mr. Rylander, did you receive those documents?
Yes, I did.
Okay, did you send in any additional documents that are not included in the packet?
No, I did not.
Okay. Mr. Wilson, did you receive the documents that we were just discussing? Mr. Wilson?
Yes, ma'am.
Did you receive the packet?
Yes, I did.
Okay. And did you send in any additional documents?
No, I did not.
All right. I will take administrative notice of the fact that the filed documents were copied and mailed to the parties along with the notice of the hearing. Now, this hearing was brought about because the employer filed an appeal that was dated August 16, 2021 to two determinations. One dated July 22nd, 2021, and the other was August 2nd of 2021. Now, the July 2nd, 2021 found that the claimant was approved for payment of benefits without disqualification under Section 207.044 of the Texas Unemployment Compensation Act, and so the claimant was not disqualified from receiving unemployment benefits, and there was no chargeback ruling as the employer had filed a late protest. And speaking of the late protest, on August 2nd, 2021, which is the other determination the employer appealed, we found that the employer filed the the response to the notice of application for unemployment benefits. After 15 days, the law allows 14 days to respond, and so that will be the other issue that we will cover, is whether the employer provided a timely response to the notice of application for unemployment benefits. Now, I am going to ask each person questions to bring out the facts, and what I'm going to do is ask one person questions, then I will give that person an opportunity to add relevant information. Then there will be cross-examination. You have a right to ask questions of the witness and cross-examination of the witness. I do ask, though, that you do not prompt the testimony of a witness. In other words, please do not help another witness answer questions. And as far as documents, please do not refer to any documents that have not been previously disclosed. Now, after the testimony is complete, I will adjourn the hearing, and then I'll prepare a written decision and mail it to both parties within the next few days. If either party disagrees with this decision, you have a right to appeal it further. Now, you'll have 14 days from the date the decision is mailed, not the date you receive the decision. So it is important that I have a correct and complete mailing address. Mr. Rylander, I have 14300 Ella Boulevard, apartment 201, Houston, Texas, 77014. Is that correct?
Yes.
And for the employer, Mr. Wilson, I have the hearing representative company of Talks UC Express, P.O. Box 283, St. Louis, Missouri 63166-0283. Is that the correct address?
Yes, it is, ma'am.
Okay. Now,
are you going to call Mr. McCleve?
Oh, you said to wait till his testimony was needed, but I can go ahead and do it now if you like.
It would be nice if his testimony could begin at least our testimony regarding timeliness.
Okay. All right, let me get him on the line then.
Thank you.
For calling the Equifax Unemployment Cost Management Team. Please listen carefully as our menu has recently changed. If you know the extension of the person you are calling, please press 1. If you do not, please enter your consultant's extension followed by the pound key.
That should be 3121 pound.
Right. Unfortunately, I mistyped it, so I don't know what happened now.
I could not locate that extension. Please re-enter your consultant's extension followed by the pound key. If you cannot locate, if you have a reference number of the case you are calling about, please press 1. If you do not, please press 2.
2.
Thank you. One moment while I transfer your call. Your call may be monitored for quality assurance and training purposes.
Equifax, this is Bill. How can I help you?
Hi, this is Hearing Officer Solomon with the Texas Workforce Commission. Are you ready for the hearing?
Yes, I am.
All right. So we already started the hearing and we went over the issues and the instructions. Mr. Rylander, did you have any questions about the procedures?
No, I do not.
Okay. And Mr. Wilson, any questions about the procedures?
Not at all, ma'am, no.
Okay. Then I'm going to swear everyone in. Mr. Wilson, will you be providing testimony?
I will not, no.
Okay, and Mr. McCleve and Ms. Allen will be?
Yes, ma'am.
Okay. All right. Do all of you swear or affirm the testimony you're about to give is the truth under penalty of perjury, Mr. Rylander?
Yes, I do.
And Mr. McCleve?
Yes, I do.
And Ms. Allen?
Yes, I do.
All right, now I need each of you to identify yourself for the record. Please state your name, spell your name, and state your date of birth. Mr. Rylander.
My name is Yacob Rylander, YUCOB RYLANDER, born February 13, 1971.
All right, Mr. McCleve.
Bill McCleve, BILLMCCLEAVE, birth date 8/30/76.
And your title?
Unemployment Determination Specialist.
Okay, Ms. Allen.
Yvonne Allen, IVONNEALLEN, Associate Labor Relations Manager. Date of birth is 4/24/79.
Okay, and Mr. Wilson, just identify yourself for the record, please.
Surely. I'm Don Wilson. That's DONWILSON, and I'm a Talks rep representing Kroger.
Okay. All right. So I am going to start with the timeliness of the response, because if the response is not timely, then the employer does not have, it will not be a party of interest to the separation. So we'll start with that. I'll take testimony on that, and then I will go ahead and go to the separation issue. I'll start by getting background information from both parties, and then the actual testimony will begin with the party that initiated the work separation. All right, so all right. So first, I'd like to admit the documents into evidence. Now, by admitting them into evidence, I'm not saying that they are correct or true. What I am saying is that these documents would be available for us to discuss. You can tell me what you agree with or disagree with in the documents themselves. Mr. Rylander, do you have any objections to admission of those documents into evidence?
No, I do not.
All right, and Mr. Wilson, any objections?
Not at all, ma'am, no.
Okay. So 1A through 37A will be admitted as Exhibit 1. Now, we want to talk about, okay, so on page 15A is the employer's response to the notice of application for unemployment benefits, so that's 15, 16, and 17. And on page 30 is the actual determination, which found that the employer provided a response, but it was 15 days after the notice, and instead of the 14, which is allowed by law, Texas law. And the employer did provide a timely appeal. So, Mr. Wilson, who am I talking to about the late petition or late protest?
Bill McCleve.
Okay. Mr. McCleve, hold on, let me just... All right. So how does the employer receive their documents? Is it by mail or by sides?
Sides.
Okay. All right. And so
You're
that would
talking
be
about the
page...
claim response, correct?
Yes, sir. Yes, sir. All right. So
okay,
15A...
Yes.
All right. So on 15A, it says that the notice was sent on July 6, 2021. It was due on July 20th of 2021, and that the employer responded on July 21st of 2021. And I'm looking for the response. August 20th. Mr. McCleve, how does the employer respond to the sides?
I don't exactly do the claim responses. I did the appeal letter,
okay.
But it's just sent through via the side system, via host to host with the state. So when we send it through, it goes directly to the state. Okay.
So did the employer receive the employer's response to the notice of application for unemployment benefits that was sent out July 6, 2021?
Yes.
Okay. And do you know when the employer responded?
We responded on July 21st of 2021.
Okay. Now, were you aware that you needed to respond by July 20th of 2021?
No, because on a side's response, the state is the one that puts in the due date on this, and we cannot change that or in any way. And so we're showing that the state entered the due date on this of 7/21/21, which is actually an issue that we brought up with the state and on several occasions where they use the 15th day. Not really sure the reason why, but we do always go off of the due date that's input by the state of Texas on the side's responses.
So is it an automatic thing that they respond on the due date?
No, we can't respond on the employer's behalf until the employer either gives a claim response, gives us the information that we need to respond with. And in a determination situation, it would be when they respond whether or not they would like to appeal. But in this situation, it's just when we're able to gather the information to send to the state regarding the claim response.
Okay. And August 20th, what is that? Hold on just a second. I'm trying to find. Okay, so we have some issues with sides giving 15 days and 14 instead of 14 days. So I know about that. I don't really have questions on that, but I do have. On page 30A, this was mailed out to the address we have on record, and it was due, looks like August 16, 2021, and on page 37A, it looks like your appeal was dated August 16, stamped August 16, 2021. Is that correct, as far as you know?
Yeah, that's correct.
Okay. So we don't have to address that issue either. Is there anything else that you want to add on the whole sides issue?
No, I think we've covered everything.
Okay. All right, Mr. Wilson, any questions for Mr. McCleve? As I said, I'm already aware of the sides issue, that sometimes in some places it said 15 days instead of 14.
No questions at all, ma'am.
Okay, Mr. Rylander, any questions on the timeliness of their response?
Yes.
Okay.
I have questions.
On the timeliness of their response?
Yes, I'm on the timeliness of their response.
All right, I'm going to let you ask questions, but I'm telling you that the commission, there was some mistake, and they entered 15 days instead of 14 days, and the employer filed it on the 15th day, and we're going to find that's going to be timely because of a mistake on the commission's part. Okay.
So you're telling me before I ask my question is basically irrelevant. It's basically
pretty much.
Okay.
I'm going to let you ask your questions because maybe there's something I'm not aware of, but because there was a mistake by the commission, we really can't hold that against them.
Okay. And I would still like to ask my question.
Go ahead. Okay,
this is to Mr. McCleve, is that correct?
That's correct.
Yes.
Okay, Mr. McCleve. So, is this your first time responding on behalf of this client or any other client concerning an unemployment claim?
No.
Have you done this before?
I've been here for 11 years. Yes,
11 years.
For 11
so you're
years.
an expert in your field.
I would like to think so.
Okay. Why wouldn't you know to respond before 14 days if you're an expert in your field?
we just go by the date that the commission puts in for the due date on this. And as I stated previously, this is a unknown issue with the state of Texas on the side's claims, not on all of them, but on the ones that they're given 15 days, we use that date as the due date.
Okay. So you basically wait till the last minute, is what you're saying.
Hold on just a second. We just lost somebody. Hold on just a second, please.
No problem.
Who did we lose? Mr. Wilson. Okay, hold on just a second. We lost Mr. Wilson.
No problem.
Uh-oh, now it's busy. He should know not to call. I'm showing that Mr. Wilson's disconnected. Mr. Wilson, if you happen to be still connected, please hang up the phone so I can call you back. It's saying it's busy. He's either still on the line or calling, which he should know. We don't. Okay, hold on. Still busy. Hello, Mr. Wilson?
Yes, my call was dropped. I got
I know.
I got cut off.
Something happened where you were dropped. Anyway, since you registered as dropped, we did not take any further testimony. I could play it back, but I don't. There's nothing additional. I stopped all testimony at that point. The other part of it is just me telling everybody to hold on and to trying to call you.
And I did hear the questions that Mr. Rylander asked Mr. McLeave, so I heard those.
Okay, great. And actually, Mr. McLeave was answering a question. Mr. McLeave, do you remember the question?
It was something about why the response was sent on the due date and not before, something to that effect.
I can repeat the question.
Go ahead.
Sure, please.
Okay, because your claim is that you mailed it out, I guess, at the last moment. Is that correct?
Yes, like I said, we cannot respond until we get the information from the employer. If it comes to that due date and we don't have information, we just go with whatever we do have and send it in on that due date, which in this case, I believe we had some information, but it came in on the due date, so that's the date that we responded.
Okay, so
yeah, looking at the notes, that is the case.
So I mean, I'm not saying that you guys didn't get your information late, because I don't know how Kroger send their information out. But according to what I have in this document, you guys were notified as a unit.
Which document?
Kroger, this document that I'm looking at on page, what's this? 15A.
Okay, go ahead.
15A, employer responds to notice of application of UI benefit. Okay, so according to what I'm looking at, the notice was sent on the 6th. Now, I'm just trying to get an understanding just to make sure. You're claiming that you didn't get this notice that was sent to Kroger on the 6th until 14 days later?
No, we get it on the 6th. It just takes time to gather the information we need. And plus, like I said, this was a while ago, but back in this time period, it was one of probably our busiest times through the entire pandemic. We were just trying to get through as much work during the day as we possibly could. But in this case, I have seen the final note on this is from that due date of 7/21, so that was the date that it was sent out to processing with to go with the information that we had on file.
Okay, so you were too busy to respond
before we send it.
Okay, I understand. You're saying you were too busy to respond to this. Now, I don't have any further questions. Well,
okay.
I'm just repeating what you just said because you said you were busy. So.
Okay, and what you're doing is making a conclusion. You should only ask questions at this point.
Okay.
All right. So we're going to go ahead and move on to the separation issue. Now, like I said, I'm going to ask background questions of both parties. Please just answer the question I ask, and then I will start with the party that initiated the work separation. Hold on 1 second.
Excuse me, ma'am.
Yes.
Can Mr. Rylander leave the hearing now?
You mean
not Mr. Rylander. I'm sorry, Mr. McCleve.
Yes, because his testimony is no longer needed. Mr. McCleve, you want to be disconnected?
Yes, please.
All right. Thank you. All right. So we're going to start with the separation information. Mr. Rylander, where's the last place that you worked before you filed for unemployment?
Kroger.
Okay. And what was I have your dates of employment is October 3rd, 2018 through June 25th, 2021. Is that correct?
Yes.
Okay. And what was your title?
At the time, I was a forklift operator.
And your approximate pay rate?
$19.88 an hour.
And were you working full-time or part-time?
Full-time.
And the employer, that's the grocery store, is that correct?
It's a warehouse.
And were you, in your opinion, discharged or did you quit?
I was discharged.
Okay. All right. Mr. Wilson, who would have the background information?
That would be Miss Allen.
Ms. Allen, do you agree with the background information that was just provided?
Yes.
All right. Since both parties are in agreement that this was a discharge, we're going to begin with the employer because they're the ones that initiated the work separation. Ms. Allen, do you know who discharged the claimant?
Yes, that would have been, the manager was Cody Camp and the supervisor was Chris Merrick as approved by HR and in unison with the union steward.
Okay. And was this done in person, on the phone, by letter?
In person, and a letter was issued to him at the time of the termination.
Okay. And what was the reason given for the discharge?
Mr. Rylander failed to report an accident that he was involved in.
And when did the accident occur?
It happened on 9/23/18. I'm sorry, 6/23/18.
I'm sorry, 6/23/18?
I'm so sorry, 6/23/21. 6/23/21.
Okay. All right. And what happened?
Sure. Mr. Rylander had hit the staircase with the forklift that he was operating, and our policy is that he reports all accidents immediately, and he did not report the accident. It was actually only because other associates saw the accident and reported the accident that we were notified of the accident. We confronted him, and he said that the reason why he did not immediately report it at that time was because he wanted to ensure that he finished his work first, that he wanted to deliver his water load. According to our production records, the water load was delivered at 9:18, and he continued to work and deliver other loads until 9:49. Again, our protocol is that he stops working right away, report the accident right away so that the machine, the forklift, could be inspected right away to make sure that it's not damaged. Again, he hit a staircase, so we needed to have closed off the staircase, make sure that it was not damaged so that nobody could get hurt as they were walking down the staircase. And he did not do that. He continued to work till 9:49, and it was only once we approached him that he admitted to the accident. Now, when we went to, he was part of the union. We are a unionized environment here. We had a Step 2 hearing case to discuss his termination. At that point, he said that the reason why he did not report the accident was because he was not hurt and the equipment was not damaged, but it is not his role to determine when an accident is or isn't reported, and he cannot determine whether a forklift or a staircase is damaged or not. And that's why we have the protocol to ensure that any machine that's into an accident needs to be inspected by maintenance. And again, he hit a staircase that people walk on all day, so that needed to have been reported and inspected. Now, if you look at page 21A and 22A, upon him being hired, he specifically signed off that it is part of his responsibility to report any accident or injury to manage immediately. And again, page 22A specifically shows that he was given all of the work rules and that safe behavior is a condition of employment, and he must report accident, injury to supervisor immediately. And he did not do that. Again, he was part of the union. We had his hearing, and when we had his hearing, he had submitted a grievance that specifically said that the sound of the accident was shocking, and he was discombobulated. So obviously it was. I'm
sorry, is that grievance a part of this packet?
You're not. I'm the one that's speaking right now, so please do not interrupt.
Hold on. Wait. Stop, please. He has a right to object. Ms. Allen, are you reading from a document?
That was part of his grievance. What I was trying to say was that...
Okay, hold on. Mr. Wilson, we can't allow her reading from a document that's not admitted. Is it in the documents that we have?
No, she's not reading from what she is doing is testifying to what she experienced. She was at the grievance meeting.
Okay, that's not what she just said. So, if you were testifying, that's fine, but do not read from a document, okay, Ms. Allen?
Okay. So, what I was referring to was that, at the hearing, he was saying that the accident was not an accident, that he was not hurt, but again, it is part of his responsibility to report all accidents. And on the day of the accident, he actually even left early. He requested to leave early because of the accident. At the Step 2 hearing, Mr. Rylander actually walked away from the Step 2 hearing, thereby at that point, any decision on his employment was, could no longer be done because he walked out of the hearing himself, thereby waiving any future rights to the grievance process because he walked out.
Okay. So, we're not going to focus on the grievance or the grievance hearing because we're only concerned up to the time he was discharged. All right. Anything? Well, let me ask you this. So you said, when did the accident happen?
It was 6/23/21.
What time?
It was around 9:18.
Okay. And you said that he delivered his product at 9:18. Yeah, and then at 9:45, what happened?
He continued to work from 9:18 until 9:49, and at that point he was confronted by management to ask about the accident, and that's when he admitted to the accident.
Okay. Now, in his statements that we have admitted into evidence, he says that, let's see. Okay, so he says on page 12A that this is not an accident, it was an incident. It was not a workplace accident, and there is a difference between incident and accident. Is there a distinguishment between accident and incident?
No, there isn't. That's why, again, the document that he signed off said that any accident needed to be reported just to ensure that the equipment and what he struck was safe. So they have to report all accidents, any accident.
Okay. But is there a distinguishment between incident and accident? Is there anything in the policy that calls it an incident versus an accident?
No, everything's considered an accident.
Okay. He also said that he was involved in a minor accident, and that usually gets warnings except for him. Why would he be discharged instead of written up?
A couple of things there. Again, he was terminated for not reporting the accident. And again, if he had any questions about the process, that's something that could have been discussed at the Step 2 hearing. But when he walked away of the hearing, all conversation stopped. So if he did not agree with the process, again, that's something that he would have discussed at Step 2, but he walked away of the Step 2. But again, he was terminated.
Well, let me ask you this. Your grievance process, does that start after he's been discharged, a decision to discharge, or is that part of the process of discharge?
No, they're first discharged, then they file the grievance, and then we have the Step 2 hearing to decide.
Okay, so we're not going to focus on the hearing because that happened after the separation. All right, now he said, let's see, looking through he mentioned something about filing an EEOC. Are you aware of any filing of the EEOC?
Yes, I am.
And when did he do that? Do you know?
Yeah, give me 1 minute. Hold on. He filed it, I have the copy in front of me. It was signed on 8/13/21, 2/57.
Wait, hold on. 8/13/21, so after the separation.
Correct.
Okay, we're not interested in that because it happened after the separation. All right. Let me see if there's anything else we need to address. Now, so he didn't report it. It happened at 9:18 or somewhere around there. So, around 20 minutes? No, about 10 minutes. No, 20 minutes later. 38.
Yeah, from 9:18 to 9:49, so about 30 minutes.
Okay.
And again, it was because we confronted him, not because he disclosed to himself.
Okay. Now, are all individuals that failed to report an accident discharged?
Yes.
Okay. And does the policy indicate that somewhere?
Yeah, yes, it does. Again, it's part of the union contract, and again, it is a document that he signed, 22A and 21A, that he has to report accident immediately. It's a condition of employment, and
okay.
That is consistently followed.
All right. Now, you said he left early that day?
The day of the accident, yes, he asked to go home.
Did he say why he wanted to go home?
From what I understand, and as I mentioned earlier, because he was pretty distraught at the accident, is what I understand. And again, that's something that was discussed as part of the grievance process.
Okay. All right. And he says he's not the only person that had hit the bottom of the stairwell. Would people who hit the stairwell be immediately discharged?
It's not so much for hitting the staircase is for failing to report the accident, because by not reporting the accident, the machine is not immediately inspected, and other people will get on the machine afterwards. So that's why it's crucial that they report it. And again, the staircase, people walk on it all the time, so that staircase needed to have been closed off and inspected. And when he failed to report it, it jeopardized the safety of other people. So it was not the fact that he hit the staircase, it's the fact that he didn't report it. Had he reported it, he wouldn't have been terminated. He would have just been disqualified from the job that he was in and put into a different job, but into his previous job, but he wouldn't have been terminated. It's the fact that he didn't report it that caused the termination.
How long had he been a forklift operator?
He had just became a forklift operator. He had just gotten, that was actually his first week on that machine. It was just his third day, but regardless of the title that you hold, the expectation is that you report any accident immediately.
Okay. All right. And had he reported any complaints to Human Resources about management or the work environment prior to the accident?
Yes, he had.
Okay. What were the complaints?
Mr. Islander believed that any disciplines that he had received before for productivity were as a result of his race rather than for his own actions. But that would not be the case.
Okay. Had the Human Resources investigated?
Yes, I did.
Okay. You said you did.
Mhm.
Okay. When was the complaint?
I do not have a specific date in front of me. That was not a question that I was prepared to answer, but I will tell you that he had put in several complaints about that issue. But as I had explained to Mr. Rylander, we have close to 600 associates here, and every one of them is disciplined accordingly, regardless of his race or age or any of those factors. As I had explained to him, he had been disciplined for not meeting productivity requirements, which is all applied equally to everyone, and it's objective based on your production. You either hit the 98% productivity requirement or you don't. And when you don't hit that, people are disciplined.
Okay. And race, I don't know the race, but do you have a mixed race of individuals working there?
Yes, we are. Most of our employees are African American. We also do have a Burmese population and some Hispanics and some Caucasian, but the vast majority of our employees are African American.
All right. Anything else you'd like to add that we have not covered?
No. The only other thing would be that, he alleges on his statements in the hearing package that he should have been suspended instead of terminated, which said it's not his call to make. We do have a progressive discipline step to follow, but again, for all accidents, if you don't report the accident, it's an immediate termination.
Okay. All right, Mr. Wilson, questions for your witness.
Yes, Ms. Allen, I'm looking at page 22A, and at the top, the name is Jakob Rylander. Jakub, I'm sorry.
Yes, no problem.
Jakub Rylander.
Yes.
And the date is 10/3/18 on the right-hand top. Do you see it?
Yes.
On 22A, I'm looking down at number 1C, work rules, and it looks like it was circled. But what I would like to ask you about that is the initials to the side, is that the claimant?
Yes.
And what does that signify, YR?
That would be that he acknowledged all of the work rules that were discussed with him at orientation.
And I'm looking down at number 2 at the bottom of the page, 2D. Could you explain 2D?
Yep. Safe behavior is a condition of employment for all employees. All employees are required to follow all safety protocol, and it is a condition of employment. And again, by not reporting an accident, it puts the safety of other associates at risk.
And and 2E, I think also is important. Could you please explain 2E?
Yes, it is a requirement that all accidents are reported, all accidents and injuries are reported to the supervisors immediately. And again, that is for the safety of all associates, to make sure that all equipment is immediately inspected and anything that was hit, damaged is immediately inspected. Whether or not you can see damage on the machines or on the stuff that was hit, the staircase in this case, everything has to be reported immediately so that it can be inspected by our maintenance team to protect the safety of all of our employees.
We're starting to repeat testimony over and over. Mr. Wilson, other questions that doesn't require the testimony be repeated?
Yes. Once again, on 21A at the top information after the title of the page, is that well known throughout the 600 people that work for the Kroger at that location?
Yes, it is. It's constantly discussed at all huddles, meetings, and again, it is something that's covered at orientation.
Was this the first accident that Mr. Rylander had?
No, he had been involved in other accidents.
And had he reported them promptly?
Yes, he had.
Thank you. I have no further questions.
Mr. Rylander, questions for Ms. Allen?
Yes, I do.
Go ahead.
We're not gonna go over the whole thing because I would like my own testimony, but just a brief citing. So, this is an OSHA regulated facility. Is this correct, Ms. Allen?
Yes.
Okay. OSHA has certain guidelines, certain required protocols to be followed after an accident. Are you guys claiming that you followed all of the OSHA regulated protocols after this accident?
All OSHA requirements that we are required to follow are followed, yes.
Okay. So how would you define a workplace accident, Ms. Allen?
Again, the expectation of all of our associates is that they report any accident.
Okay. And how would you define a workplace accident according to OSHA standards? Because this is an OSHA regulated facility. How would you define to your employees? How would you describe to them the difference between a workplace accident and carelessness, which is a write-up that you guys write us up with? How would you define the difference?
In this case, you hit a staircase with a equipment here, a forklift, so that would be an accident. There was a collision. The staircase was struck.
I'm sorry, Ms. Solomon. Ms. Solomon, she's being equivocal. Can you get her to answer the question specifically?
I cannot make her specifically answer your question, but I will take it into consideration that it was not answered. Okay. Other questions?
That's it.
Okay. Then I want to move on to the claimant's testimony. Mr. Rylander, did they tell you why you were being discharged?
At the time, they did not.
Okay. When did you find out?
When I came back from work. So to give some clarity to the situation, on the 23rd, which was mentioned, so I can bring that up, and I was there, she wasn't. So all she has is testimony that she heard. So I didn't respond to anyone saying that I wanted to go back to work to finish my route as the reason why I didn't report any accident. Okay?
So what happened on the 23rd?
Okay, so I was still in training. So I was on my way to drop off a load of water, and two associates walked in my path. Now we have a green line that they're supposed to stay within, so the forklift drivers can go by, which would keep them safely underneath that steel rail that she's talking about, the steel stairwell. They walked in front of my path. Which, video evidence will show, which caused me to skew a little bit to the left. Now, me being new on this forklift, not making an excuse, but, now I made contact with the bottom of the stairwell. I checked my forklift, which I know how to do, as they told you I've been in an accident before. And I checked the stairwell, which is iron, so nothing was damaged, and, of course, nobody was hurt. So I went back to work. But them being in my path caused me to skew off to the side. Now, naturally, this is a walkway, so I'm not speeding through. I'm not trying to kill anybody, This wasn't.
So they're not contending. They're not contending the accident was a problem. Just that you failed to report it. When did you report the accident?
Okay, so I had no reason to report it as an accident, as I told them in the office, because an accident, which they well know, is an incident that results in injury or damage.
Where are you getting your definition?
OSHA. These are the OSHA guidelines. This is the legal definition of a workplace accident.
Okay, hold on. Hold on. So that's OSHA, but this is a employer policy.
Exactly. So if they don't go by OSHA guidelines, then they should have some specifics that we should be able to know about. This shouldn't be a secret. Somebody should have in the contract exactly what an accident is. Is that correct? So I shouldn't have to guess.
What is your definition of an accident?
Injury or damage. Because that's all we have to go by. We don't have anything else. So now they also have a write-up, which she's not telling you, of something that they call carelessness, which would be something like this type of mistake. It's carelessness, something that you accidentally do, but nobody was hurt and nothing was damaged. So they have a write-up called carelessness, which they could have wrote up for me.
So
but they
were you
chose
ever
not
going
to
to report? Were you ever going to report the accident or the incident, whatever you want to call it?
I had no reason to. Nothing was damaged and nobody was hurt.
Okay, but how do you know nothing was damaged in the staircase? I mean, it's a structural structure. So how do you know nothing was damaged?
I looked at it. So it's an iron stair. It's not some flimsy staircase. This is iron, and it's very sturdy. And it's a short walkway. It's not a long structure. I mean, you have to have a picture to see what it is. Okay? It's not some long structure that the forklift can go and tear up. It's a little curve that you walk on to go to the top. This is the bottom of the stairway. I didn't hit the stairway itself. I hit the bottom iron part that you would consider the protective braces of it. It has an outskirt that protects the stairwell itself, the protective braces. I made contact with it. I didn't hit it like in a destroying fashion. It would take a certain speed to do that, which they are aware of. Yeah,
I'm still wondering why. I mean, that there could have been damage to the structure that you couldn't see.
Yeah,
without
and this is why,
engineer.
This is why you're here, Miss Solomon, because they know you don't know. See, they know you don't know. So that's what this because this isn't about whether they did something right or wrong. They know what they did. But this is about you not knowing. And see, they know that
so what
they
do
know
I
that
not
I know because you haven't seen the structure. You haven't seen the structure, so you wouldn't know whether it could be damaged by such small contact. You have to have the video of my forklift making contact, and you would have to see the structure itself to actually know how easily or how hard it would to be able to damage such a structure.
So under your definition, if let's say you hit a car with the forklift and there was no damage and you weren't hurt, would you report that?
A car? Yeah, I would. Yeah, of course I would report a car.
So what would be the difference between the car and the stairway then?
Is the car regulated by OSHA?
I'm asking you, why would you report the car versus the stairway?
Because the car isn't in a workplace accident. We have these definitions for protective reasons. This is why this is important. We have to be protected from an employer saying that anything that we touch is an accident. If they don't have a definition, they can make whatever they want to be an accident at any time they want to. We have to have some kind of defining lines.
Their policy, it's their policy. They could make it anything they want.
Which is why we're going to, that's the whole court case. So, because that's a matter for a judge to decide. So if they want to say that this is an accident in the court of law, under OSHA's guidelines, I mean, that's for a judge to decide. But you're saying that you fired me for this? Like, I can't dispute their reasoning for claiming they fired me. I can only dispute whether it was just. And according to what they know, according to what...
I'm just wanting facts of the case here. So the reason you didn't report it is because you didn't consider it an accident. Is that correct?
I didn't consider it an accident, exactly. Now...
Well, who is the one who's supposed to... Hold on. Who is the one that is supposed to decide whether it is an accident or not?
That would be me, because I'm the one that have to report it. So
all right.
Right. Okay. So that's what, when I was in the office talking to the management, that's what I told them. That's the response I gave them. I didn't say because I wanted to go and drop off my load. That was the point to this whole story. So, you know...
So you went to the management and told them?
When they called me into the office, I didn't go to them. They came and found me. I was still working. So they came and found me right where they assigned me to be at. And they told me to come to the office. Okay, I followed them to the office on that same forklift. Okay? So then we had the conversation. After the conversation, they wanted me to go back to work that same day. So they didn't want to fire me. That wasn't their agenda. The people in the office at that time, that wasn't their agenda. They wanted me to go back to work. But I have a medical condition, okay, because I was poisoned by ITC. So if my nerve starts, if I get too nervous or get too stressed out, I will lose balance. I have an acute cerebellum ataxia. I won't be able to walk. Okay, that's why I went home, which Miss Allen is very aware of that condition. But that's why I asked to go home.
Did the accident bring this on, or the fact that they were wanting to discuss it?
Both, because first of all, I'm new on the forklift, so I was already nervous as it is. The sound of metal hitting metal is jarring. I don't care how hard you hit it. You don't have to hit it hard. It's a jarring sound. It's shocking. So I got over the jarring sound and I continued my work. But, it just, not to say that you would understand this, but when you have this chemical, I got benzene in my system. It's not your fault. It's not their fault. That's not what I'm blaming on them. But when I get stressed, I get gait. I have a gait instability. I can't walk. I already felt it coming on. Them bringing me to that office and asking me to get back on that forklift, it just took me over the top. I can feel it coming on. So I asked them if I can either pick cases on the floor or go home. And they wouldn't let me pick cases on the floor, so I went home. That's how that day ended. Okay. So when I came back, that's when they informed me that I was fired immediately. So I asked them why. And, the representatives, as she said, they said that I should have been suspended instead of fired immediately. That was the union representatives that's on site. That's who she's referring to. Because they also know the rules. They know how the process is, and they know a whole bunch of people have hit that stairwell, okay? And they know a whole bunch of people hit that stairwell and did not report it immediately. That's what she's not telling you.
Hold on. How do you know that they had people that hit it and did not report it?
Testimony. I have friends who still work there. So, what
you have is hearsay. Are any of those people available to testify?
Yeah, but for this, I wouldn't see why they would be involved in this.
So let me just tell you that whatever you say here and the evidence that's brought forth here is part of the record. After this hearing, if someone disagrees, it goes to the commissioners. In that hearing, they will not accept additional evidence. This is the point you bring forth all your evidence.
Okay. Well, I wouldn't have thought to ask someone to come and testify about other people hitting the stairwell and not having reported it immediately. But I do have documentation, but that's not involved in this, which is the reason why I didn't bring it up. It's involved in the EEOC case, which is after the as you said, it's after the termination. So that which is the reason why those testimonies wasn't even thought to be brought up. Sorry that I interjected that, but I'm just trying to make a point. It's not that this isn't about what you guys know. It's about what you don't know. They know this. Is my point. It's not that they don't know this. This is something that Kroger knows.
Whatever I know has to come from the two sides.
Exactly.
If you can't inform me, then it's not going to be material because I don't have it.
Right. So that this is my effort to try to inform you as best as I can with as much information that can match the documents that we have. So I'm trying to be careful to stay within the lane that we were given. So it's easy.
Do you have additional documents?
Well, I have additional documents, but once again, they're not admitted here because they're in response. So we're still trying to stay within what we have right now. We're still trying to stay within that.
So unfortunately, because of the time, I'm going to have to continue this hearing. I thought we could get through it. It seems like the facts are fairly clear. But, I want to hear all your testimony. Do you have much testimony left?
Just before we go, just one more thing. From the document that they gave, 20A, constructive advice record. Okay.
But my question is, do you have a lot more testimony? I'm just trying to decide how to continue with this. Yeah,
I do have a little more testimony because she said a lot that I have to respond to. I'm sorry.
Okay. So, no, that's fine. I'm going to have to continue the hearing. Now, what I need from everybody is any dates that you are not available for the hearing, We're talking about 2 more weeks, maybe 3 weeks away. So I need from, today is the 17th, so like March 5th on, let's say March 3rd, March 3rd, for the next 3 weeks or so into March. Mr. Rylander, do you know of any dates that you will not be available during that time?
You say March 3rd?
Yes, sir. Somewhere, or the first week of March on.
Okay, well, the first and the second is not, I'm not going to be available the first and the second. Any time after the third or maybe the fourth to give me room would be best.
Okay, so the first week you're not available of March?
Not really, to be honest with you.
Okay. Mr. Wilson, what about you?
No, I'm wide open.
Ms. Allen, what about you?
No, March 21st and 22nd, I will be out of town for work purposes.
Okay.
And then
all right.
Also on vacation the week of March 28th and the week of March 14th will be out.
I'm sorry, the whole week of March 14th?
Yes, it's the week of March 14th, 21st, the week of March 14th and the week of March 28th out for work stuff, vacation, and also the 21st and the 22nd.
Okay, so the whole week of March 14th and the week of March 28th.
Correct, and then just 21st and 22nd.
That's not giving us a lot of room here. The 28th.
I'm sorry, I didn't know we were going to go into another hearing. And
the 21st.
Yeah.
14th, the whole week of the 14th?
Correct.
The whole week of the 14th, the 21st and 22nd, and then the week of, okay. So that leaves only the 23rd, 24th, 25th, and 7th through 11th. Okay, because the claimant wants the first week off. Okay. All right, I have to continue the case. Mr. Rylander, if you're still unemployed and filing for unemployment, you need to continue doing that during the process, and you will receive a new notice of a new date and time, both parties. And with that said, then I'm going to go ahead and adjourn the hearing. It's 10:41. I want to thank you all, and we will talk again when you get your new notice of appearance.
Thank you, everyone.
Thank you. Have a great day.
And you too. Bye now.
Hello, may I speak to Mr. Rylander?
This is he.
Hi, this is Hearing Officer Solomon with the Texas Workforce Commission. Are you ready for the hearing?
Yes, ma'am.
And do you have anyone else that will be participating on your behalf today?
No, I do not.
All right, hold on just a minute. Let me get the employer on the line.
Okay.
Good morning. Hello.
Hi, Mr. Wilson. This is Hearing Officer Solomon with the Texas Workforce Commission. Are you ready for the hearing?
Yes, ma'am.
And you have one witness, Mr. Wilson?
Yes, ma'am.
All right, hold on just a minute. Let me get him on the line. I'm sorry, Yvonne Allen is your witness. Is that correct?
That's right. That's right.
Okay.
Hello?
Hi,
Hello?
may I speak to Yvonne Allen?
This is her.
This is Hearing Officer Solomon with the Texas Workforce Commission. Are you ready for the hearing?
Yes, I am.
All right. Now that everyone is present, let's go ahead and get started. It's now 7:37 a.m. on March 18, of 2022 in appeal number 3032118. This is hearing 2. Now, the claimant is Mr. Rylander with the last 4 digits of his Social Security number of 0406. Is that correct, Mr. Rylander?
Yes, it is.
And the employer is KRGP Incorporated et al. With the employer account number 07-754425-9. Is that correct employer account number as far as you know, Mr. Wilson?
Yes, ma'am.
Okay. Now, the claimant is appearing on his own behalf and appearing on behalf of the employer. Employer is Don Wilson, who's the hearing representative, and Yvonne Allen, who is the Associate of Labor Relations. Now, because there's more than one person present for the employer, I need the employer to designate a primary representative. The primary representative of the last hearing was Mr. Wilson. Mr. Wilson, will you be continuing in that capacity today?
Yes, I will. And today is the 17th, I believe, of March.
Oh, I'm sorry. You are correct. I guess wishing it was the 18th. All right. So it is the 17th of 2022. Now, all right. Now, this is a continuance, and so we've covered all the issues and all the all the rules for the hearing, and so we're not going to go through all that again. But I do need to reinstitute the oath. Do all of you swear or affirm the testimony you're about to give is the truth under penalty of perjury, Mr. Rylander?
Yes, I do.
And Mr. Wilson, will you be providing testimony?
I will not be testifying, no.
Okay. Ms. Allen, do you swear or affirm?
Yes, I do.
All right, so I need Mr. Rylander. Last time you stated your name, you spelled it, and you stated your date of birth. If you could just state your name and your date of birth for the record.
My name is Yakub Rylander, born February 13th, 1971.
All right, Ms. Allen?
Yvonne Allen, 42479.
All right, and Mr. Wilson, just identify yourself for the record.
Yes, that's Don Wilson, D-O-N, W-I-L-S-O-N, 52956.
Okay. So last time we took testimony on the employer and partially on the claimant. We continued because the claimant had additional testimony that he needed to add. Now, so we're going to begin with that, but before we do that, Mr. Rylander, did you submit any additional documents?
Yes, I did.
Okay, did you send a copy to the employer?
Yes, I did.
Okay, Mr. Wilson, did you get a copy of the documents that he sent?
Yes, ma'am.
Okay, let me see what I've got real quick. I have, looks like 18 pages, including the cover sheet. Okay, is that correct, Mr. Rylander?
Shouldn't be. Oh, well, if it's the total document, I guess I only submitted, let's see, 4, 5. I submitted a total of 5 pages.
Okay, it looks like I have documents. Well, I guess it is from you, but it looks like it's.
No, I'm sorry. That's correct. That's correct, because it does include some documents that you already have, but some that was excluded from. I'm assuming what they used to give you earlier. Just so, okay. Yeah, that should be correct. Let's see. That's 1 through 13. Yeah, that's actually correct.
All right. All right, so I'm looking through these documents, and it looks like we have, an EEOC charge. It's a copy of that. Now, when did you file? Well, hold on just a second. Let me get this. All right, so I'm seeing the EEOC charge. When did you file the EEOC charge?
Approximately a month after filed for unemployment. Maybe 2 weeks to a month after I filed for unemployment.
All right. And then let's see, what else do you have here? You said it says Kroger Supply Chain, EO, Equal Opportunity. Okay, that's the policy. I'm not sure how that's relevant. Then there's a charge of discrimination. Now, this is all after you were separated. Is that correct?
Charge of discrimination. So this is their position statement to the EEOC. So that would be actually that would be correct.
All right, and then there's a warehouse and maintenance orientation outline, and safety and accident reporting procedures, supplement F, which is work rules, and then constructive advice record, and then there's an attachment 6, which is local union 988 paper, a grievance, and then there's Teamster Local Union 988. It's official grievance report cover letter. When was this filed?
What's the date?
Was it before or after you were separated?
Oh, this was after.
Okay.
This was after.
All right, and then they gave it a grievance number, and then there's Teamster Local 988. All right. Are these true and correct copies of these documents?
Yes, ma'am.
Have they been altered in any way?
Not at all.
All right. Do you have any objection to the admission of these documents into evidence?
No, I do not.
All right, Mr. Wilson, do you have any objections?
No, ma'am.
All right. I'm going to go ahead and admit these documents as Exhibit 2. Now, granted, they were filed after the claim had been filed, so I will keep that in mind while I'm evaluating these, and it'll be about 18 pages. All right, and that'll be, let me see something here. All right, 18 pages, Exhibit 2. All right, Mr. Rylander, had you complained about anything prior to your separation?
I wrote a grievance on the manager by the name of Doug. And
okay.
When was
that?
This was in 2000. I want to say 2019. This was sometime in 2019, maybe around June or July. And in this grievance, I made a few accusations. One of them was, the discrimination towards my age. One was a discrimination towards my race, and I also accused him of going into the system and manipulating the system to alter my work progress. Just for the record, Doug is a white Hispanic, as is Miss Yvonne Allen, who did the investigation along with Sylvia Rodriguez of that grievance.
I'm sorry, you said he was a white Hispanic?
He's white Hispanic, yes. Doug was a white Hispanic, as is Yvonne Allen and Sylvia Rodriguez, who did the investigation of that grievance. Now, if you have any other questions about that, because I can come back to fill in the blanks of all of those things after.
Okay, so what happened as a result of that investigation?
They suspended me. They suspended me.
Okay, was there something that occurred that resulted in your suspension, or was it just that you filed a complaint?
Yes. So just to give you a brief background history between me and Doug, so you can understand the
May I say something here? This is Don Wilson. I object to this testimony about a grievance filed in 2019. This does not relate to our 2022 hearing and the separation.
Okay, hold on.
Claimant.
Okay, I'm going to ask some background questions to see if it is applicable or not. Mr. Rylander, is he still your supervisor, or was he still your supervisor at the time of separation?
Doug got fired.
Okay. When did he get fired?
You would have to ask Miss Yvonne Allen.
Okay, but approximately how many? I mean, you were separated in 2021. Was it long before you were separated?
I don't think so. So the exact
I'll get
date,
back.
I'm not sure.
I'm not wanting an exact date, just an approximate date.
So it was before I was separated.
Was he your supervisor at the time of separation?
No, he was not.
All right.
Okay. Now, can I make a statement?
No, we're not going to go into this. We're not going to go into it in depth because it is the time frame is not really going to apply. I mean, 2019 versus 2021. If he wasn't your supervisor at the time of separation, then it's not going to be material.
Okay. So may I make a statement?
Your Honor, may I just say something, Your Honor?
Go ahead.
Ms. Allen, right now is not your turn. Is it a process or a procedural question?
I just wanted to clarify that Douglas was not terminated. He resigned.
Okay. All right. And you should please leave this up to Mr. Mr. Wilson, if you have any further comments. Okay. So that's not of any relevance. Mr. Rylander,
yes.
Because there's such a difference in the time, I don't think that this is going to be material. Now, I'll let you make a quick statement if you want, if you can make a statement that makes it material. Otherwise, we're going to move on.
Which is exactly what I was doing. So I'm bringing this up because in Miss Yvonne Allen's testimony, she mentioned Doug in her original testimony and made an accusation that I need to respond to directly, which is one of the reasons why I asked for extra time.
Okay, what is your statement? Let's move on.
Okay, so the reason why I wrote the grievance in the first place is because of Doug, and in retaliation, which is what I accused him of, with this is, why I'm claiming that this is part of what their outcome in this constructive advice report actually turned out to be. This isn't something that, some kind of proof that I violated the regulations that I agreed to. There's more to it than what appears, and that was the point that I was going to make. That's enough. That's all I wanted to say about that. I'm ready to move on.
Okay, go ahead.
Okay, so in the constructive advice report, in the constructive advice record that they gave me, you'll see where it says supplement F3-A1, which is the document that I added to the PDF that says OSHA guidelines PDF. If you're looking in that document, you'll see at the bottom it has what the union copy of supplement F actually states. Now I want to bring
what
this
is your
in.
point?
Well, this is the reason why they fired me. So they're claiming that I didn't. They're claiming that I didn't report an accident immediately. Okay, so this is the claim that I got fired for. This is the local union's copy of what we agreed to. Okay, F1A says as any employee guilty of the following offenses shall be subject to discharge without warning. 1 says failure to properly report an accident as soon as possible. Okay, but in the supplement F area, I'm not going to read all the way through. You'll see where they have the word accident with no description of what an accident is. Here's the point. We're going to get right to it. In the Kroger's warehouse, technically we have accidents every day, all day. I'm going to give you an example. If somebody's working on, a load on the first shift, we're told, in 30 minutes we need to pick 400 cases, let's say, of different items. One of the items, or 3 of the items, is supposed to be 3 jars of ragu spaghetti sauce, just as an example. Okay, so if I drop a jar of ragu spaghetti sauce, according to the OSHA definition of a workplace accident that I have in here, if I drop a jar of ragu spaghetti sauce, technically that's a workplace accident because something is damaged. It's a damaged product, okay? But we don't have to report dropping a jar of ragu spaghetti sauce, even though a product was damaged. Everybody knows that. So we have a cleanup crew at Kroger because items are damaged all day long. So this is a common thing. If we were to report everything as an accident, like Ms. Allen made in the statement earlier, then they would have literally 900 to 1,000 accident reports every day. So they give us discretion. Right. Okay. So obviously they would have to give us some type of discretion. Mm-hmm. Go ahead.
On your constructive advice record, it said that you had hit the bulkhead by the door with his pallet jack, this causing bulkhead to fall down. Did it cause the bulkhead to fall down?
Wait, I don't. Okay, hold on. On the constructive advice record?
Yes, the next page.
Okay, hold on. Let me see. Approximately at 9:30 a.m., Dr. Care says traveling eastbound. Did not.
Okay, I think you're looking at the wrong page. This one is page 12 of 17. It says constructive advice record. Date is 4/24/21. It says on 4/24/2021 at approximately 1:24 a.m., Mr. Pruitt ran into the bulkhead by the door 25 with his pallet jack.
You have to have something. I'm not Mr. Pruitt, so.
Oh, okay.
Mr. Pruitt?
Oh, this is Mr. Pruitt. Okay, so this is not even pertaining to you. Why is this in here? These are your documents. So
I wouldn't know. I wouldn't know why this is in here, but that's not me.
Okay, but I thought these were your documents.
No, I didn't add this in there. So this is something they brought. They put in here.
Okay, I'm not sure why you sent it then, because it was from you. See at the top from.
This what I sent you is a copy of what they sent me from the EEOC charge. So I reference what I'm referencing is at the top of this charge, not this stuff at the bottom. So this is their copy. This is something that was received by the EEOC. Okay. And this one
shows that Mr. Pruitt was.
You already have this
Mr.
document.
Mr. Pruitt. All right, and Mr. Pruitt was discharged. This says that Mr. Pruitt was discharged for hitting a bulkhead. So I'm not sure that. All right, anything else here that you want to talk about then?
Yeah, I'm not sure what relevance Mr. Pruitt hitting a bulkhead have to do. I didn't hit a bulkhead. I don't even know what a bulkhead is, and nothing fell. So the difference between this grievance with Mr. Pruitt and this grievance with me is exactly what I was about to give to you. Is the point of damage? The point of damage.
All right.
Now you can see what Mr. Pruitt here have, and you can see the constructive advice report that they gave me, which you should have a copy of because I'm pretty sure they put it in the package. Let me look in the package that we had earlier. Just make sure. Yeah, the constructive advice 34A. The constructive advice report concerning me.
Okay.
So in my constructive advice report, you won't see them complaining or making any comments about anything being damaged. You don't see them making any comments about anyone being injured. Okay. So we did ask Miss Yvonne Allen to describe what a workplace accident is, and we didn't get any answer. So I asked her if this place was regulated by OSHA guidelines, because it's an OSHA regulated facility. Now, I've already proven that they give us discretion. So if you're leaving it up for my discretion to determine what a workplace accident is without any definition, then I'm going to decide to the best of my ability what an accident is in order to report it. There is no other guidelines unless I have a clear definition. Okay? So my only definition that I could possibly have would be the OSHA guidelines that are listed for every company. Those are the guidelines that I used. Now, you can look at the constructive advice report yourself. The OSHA guidelines states, if you go to the incident investigation page, this is right from the OSHA website. Everybody should know this. This is something I have to make up. In the definition of terms, they define an accident as any unforeseen event which causes injury or property damage. Okay, underneath accident, they got what they call a near miss, which is any unforeseen event that causes a disruption in the workflow. However, it does not cause any injuries or property damage. This what's called a near miss is what's on this constructive advice report concerning me. But they labeled it as an accident. Now,
okay, hold on. Let me ask you this, though. All right, so you're saying it's a judgment call. Wouldn't it be your responsibility to report it and let them make the judgment call as if it was an accident or an incident? Okay,
which brings us to part 2. Local supplement F.A. and 1. Failure to report an accident as soon as possible. Now, she said immediately, but that's not what we agreed to. We agreed to as soon as possible. Okay, which would be another judgment call. What would I determine as soon as possible? What if it's not possible for me to report it within the first hour? What if that's not possible?
Well, when did you report it?
Huh?
When did you report it?
What was it, 40 minutes later when they brought me in? When they brought me into the office.
Did you report it or did they ask you about it?
They asked me about it. So, that's when I informed them what my determination of what happened actually happened 40 minutes later. Number one, as soon as possible. Number 2, the word accident isn't described or defined neither in Kroger's policy nor in this union agreement that I have, because You have a copy of this. You don't see the word accident defined.
You've gone over that.
Mm-hmm. Okay, and it's not defined. Okay, and it's not defined that way in OSHA. So my grievance of them firing me for a reason that is not agreed upon or legally listed can't go unvalidated if nobody can prove that this word, this undefined word, is what I violated. Unless somebody can prove that I violated this undefined word, then they fired me without just cause. It can't be, I think it's like a car accident and you might have hit a pole.
Mr. Rylander, you have gone over this issue and told me your statement. So let's move on. What other points do you have that you want to make?
Okay. Well, that would, since we can't talk about Doug, that would be the final point, even though she brought that up. But
Okay, and I don't want to go into it in depth, but what about Doug is important to the reason you were separated?
Well, I mean, there's always a background to the whole thing. I mean, this is unusual. Why would someone go through these challenges? The local union, as you have in the record, the local union, they made a statement that's saying that this was unfair. You can read it yourself, and unjust. As Miss Yvonne testified, the union.
I'm sorry, but my question was, what does this have to do with Doug?
I would have to give you the background, which I don't think.
No, I don't want the background. Tell me what your point is. What does Doug have to do with your separation?
This is retaliation, ma'am. This is retaliation.
Okay, but was he your supervisor at the time of separation?
No, he wasn't.
Was he even working at the facility at your time of separation?
I wouldn't know that. I don't know when he wasn't working, so I wouldn't know when he was.
Okay, how could Doug have anything to do with you being separated if he wasn't your supervisor or working around you?
Yeah, so once again, we're going to have to go into details about the grievance that I wrote, which is not available, so I'm not sure we can talk about that. The grievance that I wrote on Doug is not available in here. So I mean, are you going to allow me to discuss that, or?
I'm not going to go into in depth when he wasn't your supervisor at the time of separation. Was he in upper management?
This is more to do with the grievance that I wrote on Doug, not Doug himself, which I repeat is not available in this packet, which is the only reason I'm not.
And that's fine. What is it that you think? What is it that you think in the grievance that you wrote would prompt your separation? Well, let me ask you this. When did you write the grievance?
It was around July 2019.
Okay, we're not going to go into that then.
Okay. June, July 2019. And so what happened during the grievance process?
We're not going to go into it. 2019.
Okay. Not gonna be
I mean, it's 2 years later.
Right.
Okay. All right. Anything else, though, that you want to go into?
Well, I mean, that's, as long as we got for the record what the OSHA standards are, local union, I mean, that's pretty much it. Everything else I wanted to make sure was just in the record. And clearly understood about how operations go at Kroger.
All right. Mr. Wilson, you have questions for Mr. Rylander?
No, I do not.
All right. I want to go back to Ms. Allen then. Ms. Allen, let's see, you're an assistant. Tell me your title, please.
Associate Labor Relations Manager.
Okay, let's go over the supervisor, Doug, do you know what happened with him?
Doug resigned on his own, and there has been a few years now. I would say probably about 2 years maybe. I did not come prepared knowing that this was going to be brought up, so I don't have his exact resignation date.
That's all I want to know. Now, the claimant said that he filed a grievance because of Doug in 2019, 2020. Were you employed at that time with the employer?
Yes, I was.
Okay. Does his grievance have anything to do with his separation?
No, ma'am, not at all.
Okay. Now, the claimant says that there's a difference between an accident and an incident. How can he tell what's an accident and what's an incident?
As you can see, ma'am, on one of the attachments, attachment 36A, that was part of the package, and 35A, they are required to report any accident to your supervisor immediately. Safe behavior is a condition of employment, and he had signed, he had acknowledged it and signed to it. Regardless of what he believes his, OSHA definition is, the company still has the requirement to report all accidents, regardless of what he thinks is or not an accident, and he did not report it. And furthermore, when he hit the forklift could have been damaged. The staircase that he hit could have been damaged, and he did not give the employer the opportunity to inspect it right away, and could have hurt someone else. So, he's saying that there was no damage, so that's why he didn't report it. Well, he did not know if there was damage or not because we didn't inspect it right away because he didn't give us that opportunity. So that's why we require all of our associates to report any accident of any type. Yes, because, again, there's damage that could be done that you could not see. It would need a mechanic department to be able to really determine that.
Okay. Now,
can I interject in the bottom?
No, hold on, please. It's not your turn. They didn't interrupt you. All right, Ms. Allen. He also says that immediately or as soon as possible is not defined. He did not report it until the employer brought it to his attention 40 minutes later. Would 40 minutes later would satisfy the policy?
No, ma'am. Again, if I refer you to 36A, which is something that he signed in his orientation, it specifically says report it to your supervisor immediately. He continued to work for about 40 minutes on the pallet jack and the forklift that he had hit, and the staircase got hit. And again, somebody could have fallen if that staircase was damaged, so it needed to have been done immediately. The expectation is that they stop working right away and they report it, and he did not do that. It was only once our supervisors confronted him after other associates had reported it that he admitted to it, but it was only once we confronted him. So no, 40 minutes when he reported was not sufficient.
All right. All right. Those are the questions I have. Anything else that you'd like to add?
I don't. The only thing would be, I guess, going back to the Justin Pruitt situation that he brought up, if I may say something about that. The employer, did not submit that as part of this unemployment hearing. He himself had submitted that as part of our response to the EEOC, and the whole point for that document was to document the fact that Mr. Pruitt himself also got terminated for not reporting an accident. So this is a consistent practice that we terminate anyone for not reporting an accident. But again, there was a document that he himself submitted as proof for this unemployment hearing. That was submitted as part of the EEOC response.
All right. Anything else?
No, ma'am.
All right. Before we move on, though, on, let's see, page 15, 16, 17A would be the employer's response to the notice of application for unemployment benefits. It was mailed out July 6, 2021. It was due July 20th, 2021. We went over this before, so the response was on July 21st, 2021, and there were details added. So that's basically the late protest and the notice of application, the response to the notice of application for unemployment benefits. Now, I'm seeing on here that there's some documents. I don't think these were admitted. These are new, pages 13B, 14, 15B. Mr. Wilson, did you send these in?
Yes, ma'am.
Okay. All right. And Ms. Allen, I don't know, do you know if these are true and correct copies of these documents, or did someone else send them in?
Those 14A and 14B you said, that
14B,
would not...
15B.
Yeah, that is not something that I have submitted, so I'm not sure exactly where that came from.
All right. Mr. Wilson, as far as you know, are these true and correct copies of these documents?
Yes, ma'am.
Do you have any objections, submission of those documents into evidence?
No, ma'am.
Okay. Mr. Rylander, any objections to the 14 and 15B being admitted into evidence?
No, ma'am.
All right. 14 and 15B will be admitted as Exhibit 3 then. All right. Mr. Wilson, questions for your witness?
Only just a couple. Had the claimant reported the accident that occurred, would he still be working for the company?
Yes, he would not have been terminated if he had reported the accident.
He had indicated in his paperwork that other individuals had not been terminated for this very type of accident, forklift accident. Were any of those individuals not reporting? And if they were, explain why they weren't terminated.
As we discussed earlier by a document that he himself submitted, other individuals that have gotten into an accident and did not report it were terminated, just as he was. Referencing Mr. Pruitt, again, he hit something, he did not report it, he was terminated. So anyone that does not report an accident is terminated.
In his paperwork that he submitted, the additional paperwork for this hearing, did he use the word discombobulated describing the accident? And if he did, could you tell me about that?
Yes, on the grievance hearing the grievance that he himself submitted, it specifically says that the noise of the impact was so loud, was discombobulated, and he opted to go home that day. So it was a loud enough noise that caused him to go home according to his grievance.
Thank you very much. I really have no further questions, ma'am.
Okay. Mr. Rylander, questions only? I'm going to get back to your comments in just a minute, but do you have any questions for her?
No, I do not.
Okay. Mr. Wilson, anything further from the employer?
No, ma'am.
All right. Mr. Rylander, you had comments, additional comments?
Yes. So, let me just for the record, when Kroger's had the forklift in their possession, when I did go to the office. What was it, 40 minutes later? They had the right to do an investigation to see if there was any damage, which should have been added to this report if there was damage, just to prove that there was some type of damage. Being that the forklift was still only in my possession during those 40 minutes, for the record, there's no reason why they shouldn't have inspected that forklift when it was brought to them. Instead, it went back to work with somebody else taking the forklift, which only video records could prove that. And they still had the chance to go and inspect the staircase 40 minutes later, which those records of the inspection should have been added to this report, which is not available to show that they checked for damage. None of those things nothing was protruding the Kroger's warehouse corporation to go ahead and inspect those items. They just chose not to. But in response to this last claim about what I wrote about being discombobulated, I don't have in this record that I asked to go home because I was discombobulated, so let that be corrected for the record. I didn't, and once I already made a statement about that in the first hearing, do I need to clarify that again here, or?
I think you've already made the statement.
Right, I already made a statement about that in the first hearing, first part of this hearing. But I mean, since we brought up, this Justin Pruitt again, I'm going to have to go back to this document from the EEOC that I submitted because that's what they're reading from, and if we can go to the section that says events giving rise to this charge. This is the reason why I submitted this, because you'll see Justin Pruitt's name, but let's see, section, paragraph 1, 2, paragraph 3 on this EEOC charge that I submitted. It says Rylander, not Mr. Rylander submitted a grievance through his union representative to appeal his termination. The company met with the union and Rylander to hold a two-step grievance process. However, Rylander refused to answer the company's question as to why he did not report the accident. Okay, so this is a false statement. So they're claiming that in the EEOC report, they're claiming that I refused to answer the company's question as to why I did not report the accident. But as
did you answer their question?
Yes, I did. As Miss Yvonne told me.
What was the reason?
Because nothing was damaged and nobody was injured.
Okay.
That's exactly what I told her.
Anything else?
Which Miss Yvonne testified to herself in her first hearing. So back to the point.
Okay, I'm aware of the testimony.
Okay, so back to the point I was making the first time. So they're telling you one thing here, but they have something else completely different that they submitted in writing to the EEOC. Okay, so look, I'm doing the best I can. I can't fight against deception. So I mean, everything has to be. If everybody's doing everything right and legally, everything should have to be common. It shouldn't be one thing here and one thing there.
Okay. There's a dispute in fact, and that's why I'm here to settle that. So, anything else you'd like to add?
No, that's it.
All right. Mr. Wilson, any questions for Mr. Rylander?
No, but based on his testimony, there was new testimony. I do have one question for my witness.
Okay. Go ahead.
Yes, Yvonne, do you know whether the forklift was checked after the accident, as well as the walkway that was hit?
Yes, it was. Any accidents, it's immediately taken to the maintenance department for inspection, and so yes, that's a standard procedure.
And would the claimant have been notified of that in any way? Is that the procedure, to let him know that we inspected it and found nothing wrong, or we found something wrong. Please explain just a little further regarding how you would or would not talk to Mr. Rylander about it.
Correct. Our standard procedures for us to inspect the equipment, and if it's damaged or whatever the outcome of that inspection is not something that is shared with the associate. That's his management, process. The only time that it is, that we might report it back to the associate is if there was, a significant monetary damage, or if there was, significant damage to the equipment, we would have, notified, because it could have resulted in a different discipline for him. But in this case, it was not damaged, and we wouldn't go back to tell him that.
One last question. Could the claimant have gotten his job back had he not walked out of a grievance meeting, had he continued with that grievance meeting and won it? Would he have gotten his job back?
The grievance process is there specifically for that reason. He did not complete, the grievance process, so he walked out. So, yes, there could have been the possibility of him getting his job back, getting reinstated, if he had followed the process, the grievance process, yes.
Thank you. I have no further questions.
Mm-hmm.
All right. Mr. Rylander, any further questions from Ms. Allen?
I have no questions, but I do have a rebuttal.
Okay, go ahead.
Okay. So in her testimony, she just made two contradictory statements. She claimed that it was damaged, and then she claimed that it wasn't damaged. That's the reason why they didn't inform me. In this constructive advice report, on the one that I have concerning me, the word damage is not mentioned, nor any price. But the one that they have for Justin Pruitt as their example, it is mentioned. So if one of these two things can exist. If there's damage in a forklift, we would be charged for it, is what she's trying to say. If it's significantly damaged enough, they charge us for that. They don't allow us to just get away with, damaging things that we don't report. I mean, not damage it and not reporting it. Can, according to what they told us, let's just go like that. They can charge us for that. Being that they terminated me, I don't see why they wouldn't mention how that the forklift was damaged in this report when they mentioned it in his. Nevertheless, the grievance part, which is not, I don't know why they keep bringing it up. That has nothing to do with the initial separation. But, in the grievance part, Miss Yvonne was irate, and she got disrespectful. And she stood up over me and with a condescending tone and raised her voice. She elevated herself.
Okay.
That's the reason I left. Now, we was already there for 30 minutes, so,
Okay, both parties had initially... Hold on. Both parties had initially agreed that it was a discharge, so we're going with that.
Right,
Anything else?
No, ma'am. That's it.
Okay. Mr. Wilson, any questions for Mr. Rylander?
No, ma'am.
Mr. Wilson, anything further that we've not covered?
No, ma'am.
All right. Mr. Rylander, anything new we've not covered?
No, ma'am.
Then I'm going to go ahead and adjourn the hearing. It's now 8:26. I will issue a written decision within the next few days. If either party disagrees, you do have a right to appeal it further. You'll have 14 days from the date the decision is mailed, not the date it's received, to appeal. And Mr. Rylander, I don't know if you're currently unemployed, but if you are, you need to continue filing your requests for payment every 2 weeks. If, like I said, I don't know your status. So with that said, I want to thank you all for participating and have a great day. Thank you.
Thank you, Ms. Solomon, and the best of luck to all.